Concerned citizens of Tarpon Springs, Inc. versus City of Tarpon Springs et al. Good morning.
Good morning, judges. My name is Jane Graham, and I represent the concerned citizens of Tarpon Springs. I'd like to reserve 5 minutes for rebuttal.
Yes, ma'am.
Cheese on a cheeseburger, sugar in coffee, butter on bread. These are secondary, complementary additions to a main ingredient, which is primary. In this case, the circuit court failed to apply the plain meaning of the terms primary and secondary. Contrary to the plain meaning of primary use and secondary use in the land development code of the comprehensive plan, the circuit court erroneously determined that the city could approve a residential use as the exclusive use on a commercial site when only a secondary residential use could be approved. The circuit court further failed to apply the correct law by allowing this approval of a primary residential use on a commercial site through the conditional use process, circumventing the state mandated land use amendment process under Chapter 163. This is an egregious miscarriage of justice because by Morgan Group's planner's own admission, had the right procedure been followed, the project would have been denied because it increased residential
Council, let me
density.
jump in for a minute. We're here on second tier cert, correct?
Yeah.
So what do you have to show in order to get relief?
Right, so, based that that it was the incorrect law. And we are based.
Well, hold on. Let's take that a little further, because our review is about like this, correct? There's certainly due process. I mean, although it went late, fighting City Hall is not an easy job. And invariably, you're there late. If you're a citizen or an entity like yours, we understand that, and we have some sympathy for you. But you were there for 6 hours, 7 hours, and you had an opportunity. I do have a question. So, are you saying the court applied the wrong law or interpreted it incorrectly?
You're saying that the court applied the wrong law, like the Kaufman case. This is not like an Ivy case or the Custer case. And here's the distinction. So the court applied the wrong law by approving a type of residential use through a conditional use process.
And they should have amended the future comp plan.
Right, where it should have been done through a future land use map amendment.
But
So
what
it's
does the
wrong-
text, what does the text of the applicable code say about primary use? The full text. And then, because it continues on and talks about secondary uses, which includes residential in a commercial development area, right or not?
So the text explains that primary use is the predominant use.
We're not talking about the text. Let's just read it together then, if that's what it takes, because the court did it. It talked about primary use. It gave the definition, but it also allowed a secondary use, which the court defined. And it said that secondary use includes exactly what Morgan tried to do, or did accomplish, correct?
I would disagree with that, Your Honor. because
Where?
This is in the appendix A 266, the definition of secondary use is within the future land command. Secondary uses typically serve support functions to the primary land uses and are of secondary importance in terms of an area having zoning group. And in reading secondary use, what the circuit court said is that you can have a secondary use alone, but a secondary use alone is actually primary use. This conflicts with the plain language, which is a violation of clearly established principle of law, where courts must apply the plain and unambiguous language of relevant statutes. Courts may not insert words or phrases into enactment to express speculative intention unless it's clear that the omission was inadvertent. And courts must construe related statutory provisions in harmony with one another. So whereas there is a primary use, the existence of secondary use means there is a primary use. Here it is undisputed in the record that the Anclote Harbor project is for a 404 unit apartment complex on a vacant site and no commercial, no office space, only apartments with apartment amenities. And the circuit court even quotes city planner Rennie Vincent's report saying that this was not a mixed use project. Morgan Group's planner also testified that this is a solely residential use.
So, but you're quoting your own witnesses, correct?
No, these are the witnesses, the city planners, witness Renee Vincent, and Morgan Group's planner is the one who testified. She admitted that this is a solely residential use on the property. This is on transcript page 197. And so going back to the plain language argument, you cannot, interpreting the plain and unambiguous language of relevant statutes, you cannot come up with some speculative intention. And you need to construe related statutory provisions in harmony with one another. If there is a secondary, it means there is a primary. The intent of this commercial.
Yeah, but you're omitting it unintentionally or intentionally that the secondary use supports the primary use.
Right, so
Even the definition of secondary use includes primary. So it appears what Morgan did was they used the vehicle through the CPFLU to apply for this secondary use on this piece of property.
but Judge, there is no primary use because they applied as a secondary residential, and that's.
Tell me where the code does not allow, because that's what the judge said they did. It does.
So it goes to the plain language because secondary uses typically support.
No, I just asked you, tell me where the code doesn't allow them to do what was allowed by the city. You keep telling me what secondary and primary uses are. I know that.
So under policy 2.4.3, where it lists commercial general, under D, they list the primary uses, which shall include office, personal service, office support, retail, commercial business service, transient accommodation, wholesale, and storage warehouse. Primary uses does not list residential. Secondary uses does include residential, but it says requires conditional use for compatibility, but that is only for secondary use. And if you look at the idea of expressio use alteris exclusio, if you have a list of types of uses and one is omitted, you cannot think that that omitted use is in that list. And so primary uses includes a number of different types of commercial type uses, but that does not include residential.
I'm still waiting on the answer. Where does it say they cannot do what they did by applying to allow this secondary use? The city allowed them to do that. You keep telling me what a primary use is and a secondary use is, and you're trying to make them mutually exclusive. But what happens is there was a vehicle and the trial court agreed that there is a vehicle, a valid vehicle by which they can use to accomplish what they did. Is that not clear?
Judge, I would disagree because the vehicle that was used is under section 209 for conditional use approval. But if you refer back, that is only for secondary use. There is no vehicle in the code that allows the approval of a primary residential use by a conditional use. What you're doing is you're actually changing the future land use, which that would be under section 207.3, which is the future land use amendment procedure, which is also based on state statutes under chapter 163.
Well, let's take this to the conclusion that let's hypothetically say, if you're correct, and you want to have this, you want to redo, you want more hearings to determine if they could do what they did, they have to amend the comp plan. Because you started with, in this case, it's opposite of normal. You have commercial property already zoned, and they want it down zoned to residential. Isn't that a less intense use?
So the distinction is, if it's not, the idea of less intense, there's a commercial use and then there's a residential use, and in land use, there are different types of uses where residential use, people are living there 24 hours a day. So that's an important point. So for example, in the future land use map amendment project.
So you really want to see this property stay commercial?
So this is.
Or they come in to get some specific performance, and then there's an objection to whatever they want to do.
So concerned citizens' position is we want the city and we want the circuit court to follow the law, and they
Well,
didn't
the
follow
circuit
the
court
law.
went out of its way to determine that it did follow the law. And there's a disagreement with your analysis and the circuit court, but the judge went into a lot of depth in this case.
There's a case, this is Baker versus Metropolitan Miami-Dade County, it's a third DCA case, which explains that a county was not empowered to elect which plan designation apply, and that this decision must be made by the local government's governing body as the procedures require under the future land use map.
Okay, so I mean, there's a disagreement. You say they didn't follow the law, and the circuit judge said, I went through all the votes and they did follow the law, so we have to figure out who got it right.
Yes, Judge, and our position is that this is a Kaufman case where the wrong, they failed to apply the correct law.
And then what about your due process argument about the hearings going on late into the night? There was 3 different hearings that all ran over. A lot of these hearings are at night, for whatever reason, that's the way of doing things, I guess. Is there a procedure that is required to be followed in order to extend the time frame? And was it followed in this case?
So there is a procedure, Judge, that the city has for extending the amount of time during a meeting. That is true. However, the objection that concerned citizens have specifically is that the court on page 845 of their opinion explicitly said that the Matthews factors are inapplicable here. And they said it because concerned citizens participated as an effective party before the city took action, and that the city's procedures were constitutionally sufficient. But the statement that the Matthews factors are inapplicable here, that goes against existing United States Supreme Court precedent that you would run such a.
Matthews wasn't given a hearing at all on his disability. You were given 6 hours. And the mayor interjected and said that your client is an affected party. Issue over, game over. Let's look at the merits. Isn't that what happened?
So,
Is that yes or no, please?
yes,
Yes,
we were allowed to
Okay.
participate.
So you put on all your witnesses, correct?
Yes,
One of which would probably cost a lot of money. You wanted to bring remote, but that wasn't allowed. But yet you were allowed to admit his report, correct?
yes, that's right.
Okay. Is there anything, any evidence that you were denied from submitting?
Well, there was.
Yes or no? You don't have much time.
Okay, the traffic, expert that my client had was not allowed to,
But there was a traffic expert on your behalf
Yeah,
who talked about, let's build an overpass. That would be the best thing.
right. Well, Judge, I mean, I think, on the due process argument, I mean, what we would say is that under Matthews, what it asks for is a meaningful time and a meaningful manner. And the heart of the argument is that in the circuit court's decision, they omitted this type of analysis. And we would, on the due process argument, argue that the court should at least review based on Matthews whether or not it applies. And this is where the departure of the Center for Requirements of Law happened on this particular issue. With that, judges, I would just say that, concerned citizens request an opinion quashing the circuit court's decision and directing the circuit court to apply the plain language of the land development code comp plan and comply with Florida statutes governing the land use development process.
Thank you.
Thank you.
Your passion, great passion, thank you.
Okay, please support. My name is Marie Borland. I'm with Howard Henderson. I'm here today with my law partner Shane Costello. We represent the Borland Development Group. We're also joined today by Andrew Solomon from the city of Tarpon Springs, who has ceded his time to us.
Do you mind speaking into that mic? It might be me, though. I couldn't hear you.
I'm sorry, and also.
That's right, it's a new mic. It's.
And I have a bit of a sore throat, so I apologize. With all due respect, I think the court is, sees the case in the same way that we do, so I don't want to belabor any more than I need to, but I will say that we are asking the court to either dismiss or deny the petition. We're asking for a dismissal because we don't believe that this court has certiorari jurisdiction, because clearly what the petitioners are
Well,
doing.
can we talk about that for a second? What did the trial court say about that?
The trial court agreed
But
that.
then it went to a thorough analysis, even if they had jurisdiction, correct?
Correct, but the trial court expressed the opinion that this was a consistency challenge that needed to be brought via the de novo action circuit court under the statute. So if the court had stopped right there and said, the court does not have
So
certiorari.
around the wee hours of the morning, right?
Right, well, so, but again, the court, of course, bent over backward with a 53-page order and went through every hoop, as the court has already recognized.
So a complaint that the judge did more than the judge was required to do is really not a winning argument, you're saying.
All we're saying is we really were contesting jurisdiction of this proceeding, but clearly we know that the court applied the correct law. We know that petitioners were afforded.
You want this dismissal, not a PCA.
So well, either one would be fine, but I have to make the argument that we are also asking for a dismissal on the basis that there's no certiorari jurisdiction, and there's also no standing. But
Is there an appeal on this? Did you appeal that point? There's no cross appeal, is there?
no, we didn't appeal that point, but it's part
So
of
we
part
had
of
to
the
figure out what
decision.
the judge really did, and why did the judge go the extra yard?
Right, so having said that, alternatively, we're asking for the court to deny the petition because as this court has already recognized, this is second tier certiorari review, but it's not a second appeal. It doesn't concern itself with whether there was legal error. Even if this court disagreed with what the circuit court did, that would not give rise to certiorari review. So, but this court is more familiar with this standard of review than I am, so I don't have to belabor that. Here, there was not a failure to apply the correct law. The correct law was simply the comprehensive plan and the land development code. And the court, a 3-judge panel, went through an extensive analysis of all of the provisions of those two documents, that is the applicable law. We believe, and it's pretty evident from the decision, that the court applied that law correctly, but even if this court thought that the circuit court misinterpreted that law, that still would not be grounds for certiorari review. But the court, as Judge Sleet, you've recognized, nowhere in either the comprehensive plan or the land development code does it say that on a particular site that's zoned or designated commercial general business, that you can't have a residential use on that site. It's not prohibited anywhere in either of those documents, either the comp plan or the code. Nor it follows is there a requirement that there would have to be a map amendment. There would be no reason for there to be a map amendment because it's not a requirement. So in terms of secondary and primary, while I was studying this case, what really drove this home for me and put it into context is when you talk about a commercial general district, you're not talking about specific sites or parcels, you're talking about an entire area. And that's what the comprehensive,
72-acre piece,
yeah, that's well,
which is primarily general commercial to begin with.
well, that's the particular parcel, but I'm saying under the CG designation, the comprehensive plan talks about designating a commercial area in the city of Tarpon Springs, primarily along highways and commercial corridors. So if you look at the future land use plan, which is part of the law, you'll see, color coded parcels, and there are lots of pink parcels along Highway 19. Those are the commercial parcels. There's also this particular parcel or site that we're dealing with here. So quite frankly, this is a secondary use because you have lots of commercial parcels And residential is permitted within the CG designation. So it's not as if the petitioners are acting as if this is the entire CG area of the city and we are coming in with a residential use.
So they're arguing that you needed to amend the code to change the designation of this area.
To amend the comp
The
plan
comp.
to change this particular designation, there'd be no reason to do that.
But the trial court found there was a mechanism that your client utilized.
Correct. There was a conditional use approval process under 209.01 of the code, which allowed this type of review procedure. There were compatibility standards. Basically, the city commission, city staff found that all of those compatibility standards were met. I mean, in short, there was, as the court has already recognized, there were 3 days of hearings. They lasted 24 hours. They followed the code to the T. This project was found to be the best thing possible on this particular site. Our client has done so many things above and beyond what it needed to do. And Judge Monty, as you said, it's a bit ironic that we're here basically arguing about a commercial site being designated residential, which is really going to have less of an impact, on the property. So, again, in short, there was not the correct law was applied. It was applied correctly. Judge, that you've already recognized that due process was afforded in this case. The court, contrary to what petitioner's counsel said, the court devoted 12 pages of its order to due process. So the court did exhaustively consider that argument. And unless the court has any questions, we would simply request that the court, as I stated, either dismiss or deny the petition.
Thank you. Ms. Graham?
Judges, I would just argue that this case is cognizable. It was a departure of the central requirements of law. This is a challenge to the procedure of improperly changing, allowing a primary residential use through a conditional use procedure, which was not allowed. This was an exclusive residential use. The plain language of the code clearly shows that if there's, what kind of primary uses there are, and what kind of secondary uses there are. 72 acres for a 404 unit apartment complex is an exclusive primary residential use. And so we would just argue for the reasons already explained that this should be quashed and the circuit court should review based on the correct law. Thank you.
Thank you very much. Well argued. It is an important issue. We understand the environmental consequences and all of that. Thank you. Much to think about. Okay, we're going to go ahead and move on. I've been informed that all the parties are here for the last case. Yeah. All right, I'm gonna. Melones, is that correct? Good morning. Sir, help me pronounce your name.
Tasso.